Hello, everyone. Welcome to the most recent Future of Privacy Forum LinkedIn Live. Today, we are featuring two of our excellent staff policy contributors, Policy Counsels Maria Badillo and Daniel Hales, here to discuss some new developments in youth privacy law, focusing on the new Brazilian ECA, which is the digital law for children's privacy, as well as its immediate, some of the parallels and equivalent provisions that you might find in different US laws. So I think we'll start off this session by flipping it over to Maria, who is our Latin American policy expert, to discuss the ECA, its impending enforceability, and some key provisions of that law. So Maria, whenever you're ready.
Hi, thank you, Lee. Hello, everyone watching us. Thank you for being here. And yeah, happy to go a little bit over what Brazil's digital ECA is all about. As you mentioned, Lee, this comprehensive law will become effective tomorrow in March 17. And what we're saying is that it will represent a major shift for online safety regulation, not only in Brazil, but beyond, because it introduces several safety obligations, and it does so through a preventive approach, sometimes building from already existing provisions relating to data protection and privacy that are already recognized in the LGPD, but introducing and making or operationalizing this through other safety mechanisms or provisional measures. We also know that the enforcement of the digital ECA is assigned to the ANPD, which was recently transformed into a regulatory agency, so expanding the mandate from data protection to now also cover online safety for minors, with increased powers and autonomy for the ANPD. So indeed, I believe it will be very interesting to watch how this will develop in the future, right? So just to cover in the next couple of minutes some of the key elements of the law, I would like to start by mentioning a key aspect of the digital ECA, which it is what it seems to be like a very broad scope of this law. The digital ECA says that it will broadly apply to any digital product or service that is directed to or likely to be accessed by minors. And this is regardless of where that product is developed or what it is operated from. So as long as it can be accessed online by minors in Brazil. Now, what we see that it's novel here is this standard of likelihood of access, which basically considers three elements to consider whether you will be under the scope of the digital ECA. And that is considering whether your service is attractive to minors, whether it is easy to use or accessible for them, and whether it poses a significant risk to the privacy, security, and development of minors. A very important note here is that most of these concepts and what is included in this test, like in this three-pronged test, is that most of these concepts are a little bit unclear, ambiguous, or are in a way novel to how they are integrated into child safety regulation. So a lot of guidance and secondary regulations from the ANPD will be key for determining scope of the digital ECA on its own. This broad standard also could arguably mean that many mainstream platforms may fall within the scope of the law, even if they are not clearly targeting children or if they're not considering children as a primary audience of their services. So this means that companies will have to likely perform some risk assessment to determine whether their content might be accessible, might be attractive to minors, and if so, if it represents a specific harm to them. Now, before I dive into some of the key obligations under the digital ECA, a very relevant thing also about the Brazilian law is that all of its obligations seem to be rooted in the principle of the best interest of the child. This is a foundational principle in Brazil that is already recognized on a constitutional level. Also a very relevant principle in terms of international child rights law. And what it does is that in practice, it creates this broad duty of care for platforms to basically design and to operate their products and services with the children's needs in mind always, right? So this means considering their autonomy, their rights, their interests, and considering that the digital ECA seems to have this very broad scope. This might mean that the principle should be understood always as a guiding principle, as a guiding design principle for most of the digital services and products that could be accessed in Brazil. So what are the key obligations under the digital ECA? As I mentioned, this framework adopts a preventive model. And so it introduces several preventive measures that some developers must adopt. That goes like the goal is to prevent a minor's exposure to harmful content on one side. So harmful content, as we know, like anything related to, for instance, sexual content, harassment, self-harm, intimidation, all of that. But also includes under this definition of harmful content, anything related to addictive product design, right? So in this sense, we could say that it is targeting effectively two things: content, but also design or addictive product design. One of the measures is that, for instance, for preventing addictive product design, is that providers must adopt safety by design and by default measures, requiring providers to set the most protective settings by default. Just as a parenthesis here, the digital ECA also has some explicit prohibitions for providers. So for instance, it prohibits them from certain data practices involving minors, such as processing their data for targeted advertising, profiling, or for processing their data for emotional analysis. It also restricts the use of minors' data obtained through age verification for any other different purposes. And it also bans the use of reward boxes in video games, specifically for video games. So this is like some of the prohibitions that are under the digital ECA in relation to like addictive product design. But it also has a ton more of other measures. So for instance, providers are required to develop age rating policies. So this goes specifically to content, right? This means that providers must design these age rating policies and to continuously assess and monitor their content according to that policy, and perform risk assessments about the potential impact of minors' exposure to that type of content. Another safety or design mechanism that is included in the digital ECA is essentially to provide age verification tools, at the same time with a lot of data protection principles in mind, of course, like with that specifically go into limiting excessive data collection for these purposes. Another prohibition that we see here, like paired to this obligation, is that the digital ECA expressly bans self-declaration for age verification. So in that sense, it requires platforms to like abstain from using self-declaration, and in that sense adopt technically secure and auditable verification systems for these type of technologies. A very important thing here is that the digital ECA allows the ANPD to act as a promoter or certifier of some of these age verification tools. So it will be interesting to see how the ANPD in the future will become also assessing some of these technologies to see which might be like the most effective tools available. Because we know that with age verification, it is one of the key, perhaps one of the key challenges in practices, right, of how we balance effective verification on one side, and on the other side, making sure that we have enough or sufficient privacy protections for minors. Another measure that is introduced in the digital ECA are parental supervision tools. This type of tools should allow parents and guardians to basically supervise a minor's online activities. And the purpose here, again, is to target any potential exposure to harmful content, but also to limit functions that have some addictive features, such as limiting autoplay in certain platforms, or limiting notifications, and even having some controls on how children interact with AI services. So, for instance, chatbots. It is not very specific as to like specific regulation, for instance, regarding with chatbots, but it does say that parental tools should be targeting this type of interactions as well. A very important here, and linking it to how like all these obligations are rooted in the principle of the best interest of the child, is that the digital ECA also requires providers to give notice, or to notify children whenever these tools, these parental tools are active. So in a way, in my opinion, this gives a sense of how the regulation puts the child in the center, and also respects their progressive autonomy and independence. And so in a way, giving them notice of what is active, what functions have been limited, and so on. And last but not least, the digital ECA, of course, also imposes some extensive transparency obligations and reporting mechanisms. So, for instance, platforms are required to disclose any risks that they identify that are associated with their services, along with the safety measures or safety mechanisms that they have implemented in light of those risks, and any complaint mechanisms that are available for individuals. There is also like this very specific obligation for very large social platforms, which I believe are those platforms that have more than 1 million registered users, of course, under the age of 18, that must publish semi-annual transparency reports available in Portuguese on their website. So there are specific obligations for large providers, and kind of resembled a little bit some of the obligations that we see with the Digital Services Act in Europe as well. And about the reporting obligations, we see that providers also have the obligation to report any violations which are deemed serious. Of course, anything related to child grooming, sexual exploitation, kidnapping. Of course, it is still unclear how specifically the authority will determine whether there is grooming or not. How do you assess that? What type of tools you will be using to identify those type of harmful practices? But it is definitely one of the obligations that providers must take into account with the implementation of the digital ECA. And so in general, we could say that transparency obligations, reporting mechanisms, along with this safety and content measures are the core enforcement design or mechanisms under the digital ECA. I'm trying to go quickly because I know we have just a couple of more minutes. But just to close up, as I said, enforcement will be assigned to the AMPD, which again was transformed into a regulatory agency with strengthened powers. And in this role, we are expecting to see like a first phase where the AMPD will perhaps provide a little bit of more guidance, more regulations, more interpretations as to how should we interpret or understand the scope of the digital ECA, and at the same time, perhaps a period where the AMPD will act in a more, I wouldn't say less aggressive, perhaps friendly would be the right word, like a friendly phase of adaptation, right? To see how this law will be implemented, how it will be interpreted. We know that the ANPD, for instance, just recently requested information to more than like 20 something companies that perhaps obviously fall under the scope of the digital ECA, because they are specifically targeting minors, or they are offering services to minors. And in this way, the ANPD is trying to also understand. So, for instance, for age verification tools, it is trying to understand how these tools will work, what is most effective, but at the same time trying to balance all the privacy protections that are already there. So to conclude, I think the digital ECA represents this innovative approach with an integrated framework for privacy and online safety for minors that will likely make waves also beyond Brazil.
All right, thank you very much for that, Maria. Before we flip it over to Daniel, I have a couple of follow-up questions for those folks that are interested in the Brazilian law, and particularly its effective date, which is tomorrow. You mentioned that the ANPD still likely has some forthcoming guidance and regulatory documents that will accompany the statute itself. Could you shed some more light on the areas where we are still awaiting clarification from the regulator? If there are any key components of the law that folks who think that they're likely to be subject to it should be on the lookout for regulatory follow-up, basically, from the ANPD.
Yeah, so I believe there's still some, we are still awaiting guidance, for instance, on all the LGBT provisions that relate to how to process minors' data and the restrictions that go with it. So we might expect, I believe in this year, the ANPD should be able to issue some clarifying guidance around the rules and limitations around rules for processing children's data. And I believe that we might expect some already some overlap or some joint analysis from the provisions that we see from the LGBT and the provisions that are present in the digital ECA, which are mostly prohibitions, right? So what I was mentioning on targeted advertising, or for profiling, or for processing that type of children's data for augmented and virtual reality. So we might get a little bit of more clarification on those rules. And also, very importantly, I believe, so that the ANPD already issued a first study or a first analysis on age verification tools. I believe not making any conclusion on what is the most effective, but more analyzing the options that are out there. Also very much informed from these interactions with industry. But what it will be really interesting is how the role that the ANPD might take on being a promoter or a certifier of certain technologies. So I think that's at least for the companies that have it more clear that they could fall under the digital ECA. I believe it will be really interesting to follow on those further guidances.
Okay, thank you for that. That's very helpful, and I encourage our audience to keep an eye out specifically for those clarifications. Another question from our audience, right before we move over to Daniel, is enforcement complaint-based, or will the ANPD, the regulator, take proactive measures to audit platforms? And what authority and or leverage will it have over foreign companies? Those are not based in Brazil. My understanding is that the regulator has both options. It can both conduct ex officio investigations on its own initiative, and can respond to complaints from the public. And that the ECA, in fact, mandates that there be some methods of contact and a mechanism for parents, particularly, to exercise their rights vis-a-vis subject companies. And then, of course, the regulator can take action on its own initiative whenever it would like. As to the second question, Maria, do you know what is it sort of a similar similar situation to many other jurisdictions where, practically speaking, if the regulated entity doesn't have establishment or an office or staff or assets within Brazil, the authority's practical ability to enforce the law is somewhat limited, but theoretically the law captures, any company that's doing the behavior that's targeted at Brazilian youths.
That's correct. That's my understanding as well. And again, it goes specifically to the scope and this like broad extraterritoriality of the law, mostly with this standard of the likelihood of access. And the digital ECA is very clear in saying that it does not really matter whether you have presence in Brazil or where you're operating or designing your services from, as long as it is a service or a product that is offered and it can be accessible via internet in Brazil. I think you could fall under the scope of the digital ECA, and in that sense, the AMPD would have authority to enforce the digital ECA.
And I think that's a great segue over to Daniel Hales, our U.S. policy counsel, who has been following with great interest the myriad developments in this space on the U.S. side. I think likelihood of access by children is a key piece of language, particularly in those proposals that follow the sort of age-appropriate design code model. So Daniel, if you want to expound on what we're seeing on the U.S. side, where there are key differences and where there are key similarities to this ECA proposal in Brazil.
Yeah, there's so much to cover here.
Go fast.
The federal government, and then we have the 50 states, which really are proving that they are the laboratories of democracy here. So I'm going to start quickly with going over the foundation of privacy protections that we have for kids, which exists at the federal level, before I get into the patchwork of other protections that align with or contrast from what Maria has very brilliantly laid out for us coming from the digital ECA. And so at the federal level, we have COPPA. We've had that for almost 3 decades now. And COPPA addresses the collection, use, and disclosure of personal information about children collected from children through websites and other online services. Important distinction between the US and Brazil here is the US does not have like a national broad consumer privacy law like Brazil does. So a lot of these state level or like supplemental efforts to COPPA to protect children online are viewed, in my view, differently than having a bunch of proposals that can supplement what a federal privacy framework could do in the terms of protecting kids. So we have COPPA, and there's been calls for a long time to update COPPA, and we have 2 proposals active right now that the US affectionately calls COPPA 2.0, and these are just amendments to update the longstanding statute. And there's a version on the House side, and there's a version on the Senate side. On the House side, proposed changes to COPPA include raising the age thresholds to include protections for teens. Right now, COPPA only applies to under 13s. This would expand protections up to 16. It would implement a 2-tiered knowledge standard with a constructive knowledge component for large social media companies. And for that 2-tiered knowledge standard, it would maintain actual knowledge, which is what exists for COPPA for basically all operators except for those large social media companies, which it would then introduce a willful disregard component. And it would also codify an expanded definition of personal information, all of which would significantly broaden out the statute's scope. So we are seeing like a broadening of scope in terms of youth online privacy and safety in the US. On the Senate side, we see a little bit of variation, mostly for the purposes of this discussion. I will point out the knowledge standard deviation for the Senate, in which they are trying to approach it from an actual knowledge or knowledge fairly implied on the basis of objective circumstances, which is borrowed from FTC trade rules, and it is probably a lot broader and more constructive of a knowledge standard that may start to move interpretation of knowledge a little bit closer to the likelihood of access standards that we see. So that's what we're seeing kind of percolate on the federal level, but we also have the states. And getting back to the likelihood of access, or likely to be accessed by children standard, we are seeing that constructive knowledge standard circulate, as Lee mentioned, in age-appropriate design code type models. We've seen that in California, Maryland, Vermont, and South Carolina so far. And this standard generally kind of aligns in some ways with the directed to children factors established in COPPA, with some variation in there, but directed to children factors include like whether websites subject matter or visual content, or the use of animated characters, age of models, seems to be directed to children. And so I think that there is some comparison there to the way that the digital ECA is attempting to define this, which I believe included ease of use, attractiveness, and then certain risk-based factors. I would say that the risk-based factors is where there's a bit more of a divergence, but maybe there is some common ground when we're talking about attractiveness and ease of use. And then across other state law models, there have been attempts to kind of expand the knowledge standard to start to capture more indicia of knowledge that a child is on the platform, and kind of raise the threshold for companies' obligations to provide protections to children. But aside from knowledge standards, another way to identify who may be a minor online, or to identify where obligations are owed, is age assurance. And we do have a couple of age assurance proposals that are going around on the state side. Most applicable to highlight here is actually the App Store Accountability Acts, for which we now have 4 that have been enacted on the state level. And we also have a pending federal proposal that is envisioning establishing a version of that framework there. And the App Store Accountability Acts impose significant obligations on app stores and developers to conduct age verification and obtain parental consent before a minor can download an app, make an in-app purchase, or continue using an app after significant changes have been made. The states that have enacted these laws so far: Texas, Utah, and Louisiana. And this very much relates to what the digital ECA is doing, because of the idea of the age signal APIs, where app stores would be responsible for doing age verification and obtaining parental consents, and then via these APIs would transmit that information to developers to implement various age restrictions and safety features. And so we are seeing this idea of age signals kind of shift across borders now. And it will be interesting to see how those trends may continue on a greater global scale, and also how this rather novel idea and implementation of age signals starts to unfold as these laws go into effect, especially with Brazil going into effect tomorrow. On the US side of things, the App Store Accountability Act models are getting a little bit tricky. So I mentioned that there's 4. Texas was supposed to go into effect January 1st, 2026, but it was blocked by a federal court through a preliminary injunction because of constitutional concerns, namely around the coverage, concerns around it being content-based, and some vagueness concerns as well in terms of how those requirements were crafted. Interestingly, including how requirements around developing age ratings were crafted, which is something that kind of turned on the light bulb in my head when I was reading through that, considering the digital ECA framework that we see developing there. That said, newer versions of that framework have not taken the same approach as Texas has to implementing age ratings or requiring them, but it is still kind of like a feature of those laws in terms of like companies that are creating age ratings must be disclosing information about those ratings and how they were created to parents, and parental consent disclosures when complying with other requirements under the Act. So it's not explicitly requiring that companies are creating these ratings, but if you have them, you have to disclose them to parents, and you have to include significant or critical information about those ratings to parents. Starts to kind of beg the question of, is there going to be a more unified standard to app age ratings that we see developed because of the way that some of these global jurisdictions are thinking through age ratings for downloadable content like that. And then,
Daniel, I know one of the sort of longer standing criticisms of COPPA in its original construction is that it somewhat paradoxically incentivized platform owners to learn as little as possible about their users, but under the theory that if you never knew that someone was under 13, then you could evade COPPA restrictions simply by putting a term in your TOS that said underage users were not permitted on your platform. Oversimplifying a complicated issue, but a way that incentives were pushed. Do you think that with the provisions about rating different products and the transparency obligations attached to them, you will see a sort of similar issue emerge where there is what is created as an incentive for either developers who have content that may be, or products that may be geared toward youth users to, not want to essentially rate those things for because of the requirement that they'll have to publish those assessments then to the public?
Yeah, that's a good question. I think that broadly the answer is that companies and key stakeholders should pay very close attention to the interactions between these different laws and the ways that certain requirements may trigger other obligations under other laws, or complying with certain things may start to trigger knowledge under various frameworks. So I think that thinking through age ratings is certainly one way that companies may find themselves increasingly under COPPA, but also just the fact that they're conducting age verification. It will start to trigger COPPA obligations there, and potentially obligations under other state laws in those states as they continue to comply. So it's definitely a good thing to note continuously as these laws are considered and further enacted. But I see we have a question in the chat. Do we want to take that before I continue?
Yeah, sure. I was, if you want to actually respond to this, there is a question regarding whether or not, I guess, what is the word regarding the deeper level of parental consent, given that app stores are not fully offering parental consent needs at the moment. I mean, as I understand it, we're basically in a wait and see moment as far as some of these app store accountability statutes have been challenged on constitutional grounds. Presumably, if they remain in effect largely as written, Daniel went over 4 of the states that have adopted frameworks that push this burden onto app stores. We will see necessarily the platform operators have to move to some sort of standardized process for integrating parental consent. And it sounds like you're more plugged into this than I am, Daniel, but relying on APIs to push consent signals to developers that have been permitted onto app store areas.
Yeah, so there's a lot of nuance involved in this question, and it's very complicated when we start to think through the levels of parental consent that we're getting to between the state level regulations that are passing and what's going on at the federal level. So what's the word regarding the deeper level of consent here? I still don't think that I've seen any sort of federal movement to try to address this. So the App Store Accountability Act requires app stores to also obtain parental consent for minor app download, in-app purchases, and continued use after significant changes, as I've mentioned. The App Store obtaining that consent only fulfills the consent obligations for the App Store Accountability Acts. But once that developer API is sent from the app stores to the developers with that download consent, the age range, and what other else information is needed there, developers are not relieved of their obligations to obtain parental consent under COPPA. So they would still have to go and then obtain their own consent for data collection, use disclosure under COPPA. an app store cannot relieve the developer of that. So this is going to, if these laws really do start to take effect, given that there's a very complicated litigation space right now that is blocking them from going into effect. But if they were, it would create a very tricky landscape for COPPA consent flows. I have not seen any amendments at the federal level to address this situation yet, either any proposed within the COPPA framework or the ASA model that the federal government is trying to push forward. So it seems like there may still be that need to obtain the consent under the ASA laws, plus then developers going and obtaining the consents that are required of them under other laws like COPPA and potentially state privacy laws as well.
I think that's a particularly critical thing for our audience to recognize. For those of you who may be subject to both things, relying solely on a signal of consent that's been sent to you via an app store is not enough to absolve you of compliance responsibilities for other simultaneously applicable regulatory structures. I want to flip the question back to Maria for a second. Are you aware of any efforts or any desire on behalf of Brazilian policymakers to similarly pursue the sort of like the platform operator component? Do anything like age assurance at the App Store level? Or is that, at least so far, remain a pretty uniquely American approach to this problem?
I would say, like, aside from the specific provisions that we see in the digital ECA, I haven't seen like any other debates or clear debates around these issues, but I'm already seeing that this will, like all the consent architecture that Daniel was talking about, I can already see that it will be a little bit unclear, because, for instance, in the digital ECA, we do have this obligation from providers to, or not obligation, but in a way like this, that the digital ECA allows providers to receive age signals from through secure APIs from developers, but at the same time, it does not allow them to rely on those signals for age verification purposes. So it doesn't exempt providers from having to verify age through their for their services and products, and it at the same time it does not exempt like any other agents in like the digital ecosystem from their responsibilities in with regards to age verification. So definitely, at this point, I haven't seen like any debates on how that like architecture will unfold in the future, but definitely the digital ECA does have provisions that limit or more expressly establishes joint responsibility in this regard.
All right. Well, I see we're coming up on time here, so I'll give both of you, I think, the opportunity to close out with a final thought, something to focus on, what you would highlight as the most important thing to keep an eye on, respectively, regarding the implementation of the ECA, and I guess whatever's going in the blender that is U.S. policymaking. So Daniel, if you want to go first.
Yeah, I'd highlight two things. The first thing is to watch what's happening at the federal level, because that could determine a lot and impact a lot of what's going on the state level. So like I said, there's various proposals going on at the federal level. The Senate has just passed their version of COPPA 2.0. The House is moving through a significant youth privacy and online safety package, for which they just moved several bills out of the House Energy and Commerce Committee like a week and a half ago at this point, and they're still working on considering their version of COPPA 2.0. And so all of these things together, if enacted, could then set a new federal standard that could impact what we're looking at the state level, and the way that I talk about the states may be different if that were to happen. However, without federal action, something to pay attention to is just the expansion of knowledge and what is required of companies there, and then how this expanded view of knowledge and application of knowledge standards and application of scope may impact other state level requirements or requirements to obtain consent or do various other things under the already existing COPPA statute. So really just paying very close attention to current compliance flows and making sure that as you're complying with these new state level proposals, you're also paying attention to the potential impact on longstanding obligations under other laws as this landscape gets ever more complicated.
Got it. And Maria?
Yeah, and on my side, I would just say that, well, I think it will be fascinating to see how the digital ECA will be enforced in Brazil and how it will also very much likely make some impact beyond Brazil, having like in mind that this broad extraterritoriality component of the law. It will be interesting to see how the ANPD hopefully soon will provide a little bit of more guidance, some interpretations on how to understand some of this like unclear concepts that are embedded within the law. Also, I believe it will be very interesting to see how, coming from the ANPD, like the former Data Protection Authority, well, still Data Protection Authority, but now with an extended mandate, how the ANPD will enforce the digital ECA with a lot of interactions and, you know, along with all of the principles and protections that are already recognized in the LGPD. So this interplay between privacy and child safety regulation, that would be really interesting to watch. And just to finally mention that, yes, the digital ECA is becoming effective tomorrow, but I wouldn't like raise all the alarms and think that the ANPD will like instantly become, you know, in a sense, like in this aggressive mode. But I believe we should expect a little bit more of like exchange with industry and like a more cooperative or perhaps friendly face to have a better enforcement of the law in the future. So yeah, it will be really interesting to see how that unfolds.
All right, and with that, I think we'll wrap it up for today. Thanks again to our two wonderful contributors. That's for all of you watching. Policy Counsel's Daniel Hales and Maria Badillo here with the Future of Privacy Forum. And we will be back in the future with more policy developments. I'm certain we will not run out of things to talk about in the coming year.
Thank you.